as to the location of a vessel.
Chairman of the committee, those against say no. The ayes have it. Clause 132 is accordingly ordered to stand part of the bill. Clause 134.
Designated device.
Chairman of the committee. 133.
Mr. Speaker, we have no advertised amendment to 133.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, the question therefore is as many as are in favor of clause 133 standing part of the bill, say aye. Those against say no. The ayes have it. Clause 133 is accordingly ordered to stand part of the bill. Clause 134.
Photographic evidence.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Any proposed amendment from honourable members? In the absence of any proposed amendment, the question is, as many as are in favor of clause 134 standing part of the bill, say aye. Those against say no. The ayes have it. Clause 134 is accordingly ordered to stand part of the bill. Clause 135.
Admissibility of electronic or digital evidence.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, the question is, as many as are in favor of clause 135 standing part of the bill, say aye. Those against say no. The ayes have it. Clause 135 is ordered to stand part of the bill. Clause 136.
Presumptions.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment to clause 136, the question therefore is, as many as are in favor of the clause standing part of the bill, say aye. Those against say no. The ayes have it. Clause 136 is ordered to stand part of the bill. Clause 137.
Honors of proof.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Any proposed amendment? In the absence of any proposed amendment, the question therefore is, as many as are in favor of clause 137 standing part of the bill, say aye. Those against say no. The ayes have it. Clause 137 is ordered to stand part of the bill. Clause 138.
Destruction of evidence.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Any proposed amendment from any member? Yes, Honourable Richard Achampo.
Thank you very much, Mr. Speaker. Mr. Speaker, I also need your guidance on 138. The head note reads destruction of evidence. If you read the first line, a person who destroys or abandons a fish, fishing gear, net, or any other fishing appliance. So the first line is talking about destruction and abandonment. But the head note is talking about only destruction of evidence. So if you abandon a fishing net or whatever, if not destroy it, it doesn't amount to destruction. No, I've run away and I've left it. You can pick it and examine it. So in this case, if I have abandoned something, how do we get me to place fine on me? But you say if I do that, there's a penalty for it. Why are you going to find me to place that penalty on me?
Honourable Richard Achampo, if your smoke is supposed to be in evidence and you are hiding it, are you destroying the evidence? Because the destruction is not in relation to the subject matter. It's in relation to the evidence. So once it is not available to be evidence, that evidence is destroyed. my pen is supposed to be admitted in evidence, and a decision will be based on this pen. And I have destroyed this as a result of which it is no longer available. I have run away with this pen as a result of which it is not available. I have thrown this particular pen into the sea as a result of which it is no longer available. I have hidden this particular pen as a result of which it is not available. So once it is not available, for the purposes of the evidence is destroyed. That's why they are saying destruction of evidence.
Mr. Speaker, if I'm on the high sea and I run away and leave my ship or the vessel on the high sea, that sea can be found.
Or the fish. How about the fish?
The fish is in the ship. So we can find the ship, we can find the fish. I've abandoned it. But you can't find me for prosecution.
Yes, two things constitute a crime: the act and the intention.
Yes.
So, under what circumstances? so once it is intentional, that will be an element of a crime. You see, no act entails criminal responsibility unless the mind is legally blameworthy. So the dead language said, actus non facit rule, necit mens rea. That is, no act entails criminal responsibility unless the mind is legally blameworthy. So did you left it deliberately in order to destroy the evidence, or it was not deliberate? So all those things will be looked at in establishing whether or not a crime has been committed or not. As many as are in favor of clause 138 standing part of the bill, say aye. Those against say no. The ayes have it. Clause 138 is accordingly ordered to stand part of the bill. Clause 139.
Liability of master and an officer of a company.
Yes, Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, the question is, as many as are in favor of clause 139 standing part of the bill, say aye. Those against say no. The ayes have it. Clause 139 is ordered to stand part of the bill. Clause 140.
Continuing offense.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 140? In the absence of any proposed amendment, the question is, as many as are in favor of clause 140 standing part of the bill, say aye. Those against say no. The ayes have it. Clause 140 is accordingly ordered to stand part of the bill. Clause 141.
Banning order.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Any proposed amendment? In the absence of any proposed amendment, the question is, as many as are in favor of clause 141 standing part of the bill, say aye. Those against say no. The ayes have it. Clause 141 is ordered to stand part of the bill. Clause 142.
Release of seized goods.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Any proposed amendment? In the absence of any amendment, the question is, as many as are in favor of clause 142 standing part of the bill, say aye. Those against say no. The ayes have it. Clause 142 is accordingly ordered to stand part of the bill. Clause 143.
Forfeiture by courts.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, the question is, as many as are in favor of clause 143 standing part of the bill, say aye. Those against say no. The ayes have it. Clause 143 is ordered to stand part of the bill. Clause 144.
Compounding Offences Committee.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any, yes, Honourable Dr. Kabiru.
Mr. Speaker, I am proposing that 1441C should 1442C should have the National Fisheries Association of Ghana or the Ghana Aquaculture Association replaced by Fisheries and Aquaculture Association. I am making this proposal so that we can make definition for that to include that and other emerging associations, because when we say all, it's difficult to get which of them are we going to appoint. And I'm also saying this mindful of 149. 149 talks specifically about National Fisheries Association and omitting the Aquaculture Association. So because of the plurality of associations in this particular sector, to avoid people saying that I am supposed to be there, this is not supposed to be there, and leaving the discretion to the minister to determine, as the case may be, I'm proposing that.
Honourable Chairman of the committee, is National Fisheries Association of Ghana different from the Ghana Aquaculture Association?
Yes, Mr. Speaker, they are different. And if I may add, that what the honourable member is proposing will actually compound the issue in a worse form, because then these are specified, and they are those that are known and registered and have been working with the Commission and the Ministry as well. But if you allow it open like that to associations, it means you are rather empowering the Minister or the Commissioner to select which one they are comfortable with, and that will not give the kind of transparency that we are looking for.
No, the point that he is raising is a representative of the fishing industry. That one is clear. Nominated by the National Fisheries Association of Ghana. And once the National Fisheries Association of Ghana is different from the Ghana Aquaculture Association, how are they going to do this nomination? Yes? Yes, Ashai?
Yeah, Mr. Speaker, thank you. Like the chairman of the committee said, the two named associations are supposed to be the mother or the umbrella associations catering for the marine and the inland. And so whichever the situation may be, the rep, if the matter has to do with inland or aquaculture, then the rep would be coming from there. That is why they all must stand. Thank you, Mr. Speaker.
Well, it is for the consideration of the House. Yes, Honourable Dr. Kabiru.
Yeah, Mr. Speaker, I think that to avoid the problem I am preempting, and to still give the discretion to the minister to determine if it is fisheries or aquaculture, we can recouch that rendition to mean the relevant fishery association or relevant aquaculture and fishery association, so that it will still give the discretion to the minister. Because I'm saying that when we come to 149, I'm referencing that you specifically mention an association. Meanwhile, it is a reference to fisheries and aquaculture appeals. You did not mention the aquaculture, the fisheries in there. So when this argument is to hold, then we'll have to repeat the same rendition here. Or we just make it and define what we mean by fishery and aquaculture association in reference to these two, so that it prevents any ambiguity whatsoever. Thank you.
Yes, Chairman of the committee.
Mr. Speaker, this committee is an ad hoc committee. So depending on where the offense is, if it's in inland, then the rep comes from the Aquaculture Association. If it's in Marie, Troll, or even the tuna subsector, then the rep comes from the National Fishing Association. So,
But, honourable members, what is bothering my mind is, once it is an ad hoc committee, do you by law determine its composition? Yes, I will give you the floor after him.
Mr. Speaker, I think it is subject to your guidance. It may be acceptable to define the constitution of this committee, but this last one should be as the case may determine. We must add a clause that depending on the case, then you bring in. In some labor matters, you can have a disciplinary committee and you set it up and you say depending on the union that the case is coming from, a rep of that union is put on the committee. I see a similarity here. So it may be from the aquaculture or the fisheries, but there must be a clause that, or a defining sentence that as the case may determine, or determine, yes, so that where it's coming from, just as the chairman has stated, anytime you are constituting it, if the case is from aquaculture, it's a rep from the aquaculture. If the case is from fisheries, then it's a rep from the fishery, because it's ad hoc. It's as and when you establish it. Respectfully submitted.
Yes.
Thank you, Mr. Speaker. I think that legislating by mentioning the name of an association in it is quite problematic, especially when this body is an ad hoc body. And why don't we make it aquaculture or fisheries, so that as the enterprise is evolving, whether the National Fisheries Association lives or not, we can still find a leeway in that. If you mention the names of associations, it means that you are pinning yourself to a particular point. Tomorrow, these associations may cease to exist. And what do we do?
Let me pick the thought of Honorable Second Deputy Speaker. For ad hoc committee, do you determine its composition by law?
Mr. Speaker, my understanding of ad hoc is normally determined by the circumstances. So if the circumstance calls for it, then quickly we organize and establish a team to look at it. But normally legislating it, making it a permanent situation could create a problem. So once the committee is actually determining that it's an ad hoc, then probably we have to look at it from the angle that ad hoc is always based on the circumstance. And therefore, I will go by my brother who is saying once it's an ad hoc, then we have to probably lessen our position of legislating it to make a standing position of the law. So, Mr. Speaker, as it stands now, probably that will be my position.
Yes, Honorable Zanato.
Thank you, Mr. Speaker. With reference to the clause that makes reference to ad hoc, the ad hoc is in reference to the frequency of meeting. It's not with reference to the committee. The committee is established as an offences committee. So that one is there. But when you say on an ad hoc basis, ad hoc is referring to the frequency of meetings as and when is required. But the committee, a compounding offences committee, is the committee itself, which is not an ad hoc committee. It's an established committee. The ad hoc is making reference to the frequency within which that committee shall meet based on any offenses that may be committed. So the committee is not ad hoc.
So if you look at 441, the commission shall establish on an ad hoc basis a compounding offenses committee.
Yes, Mr. Speaker,
Okay.
which makes reference yet again to the frequency. So the existence of that committee, we can define what that constitutes, and that remains. But the fact is, the reference to ad hoc basis is with reference to the fact that you may not have offenses happening on a frequent basis. So as and when is what the ad hoc is making reference to.
Yes,
there.
that is the very meaning of ad hoc. For instance,
But
ad
the
hoc
committee
means,
has been
yes,
identified.
Ad hoc means as and when. You understand? That is the meaning. So ad hoc committees are mostly not permanent committee. Now, you cannot establish compounding offenses committee as a standing committee and ask that particular standing committee to sit on ad hoc basis.
Per the clause here, that's what it's implying. Because ad hoc basis, on an ad hoc basis, is making reference to the frequency of meeting.
Yes.
So
let's take
then
a parliamentary.
Mr. Speaker, if the purpose of this is not to speak to the type of committee it is, then the ad hoc basis there should go. Because ad hoc basis is talking about the frequency with which it meets, which
Yes.
the committee
Yes.
meets.
Normally, the standing and the select committees do not sit every day, but upon a referral. If a matter is referred, then you can sit. So, in a way, it's not everyday sitting. But the ad hoc committees that we have, per the standing order, the committees are not even named. So it is as and when the issue crop up, then the House will be, by a motion, form the committee to deal with that particular issue. And as soon as you finish dealing with that particular issue, that committee has done its work and the committee's existence has come to an end. So, looking at Standing Order 262, it says that the House may, by a motion, appoint a special or an ad hoc committee to investigate any matter of public importance and consider any bill or matter that is not within the jurisdiction of any of the standing or select committees. So, which means that the formation of the committee itself is on ad hoc basis. So, this one, if you are saying that it is a permanent committee, why would you then establish a permanent committee and provide in the clause that the commission shall establish on ad hoc basis? Because you are establishing the committee on ad hoc basis. Yes, Honorable Zanato,
Mr. Speaker,
I'll come to you.
Sorry.
No, you have the floor.
Okay, for example, the Committee on Petitions would usually have meetings specifically based on referrals when petitions are brought to it. But it does not mean that in the absence of petitions coming to the committee, it does not exist, even in name. So here we've been given a specific name, but the basis, the frequency for which this is constituted, because once you say that they should sit every day, it changes the dynamics of the frequency of meeting of that committee. But once you say that on an ad hoc basis, that means that you're saying that as and when there's an offense, they meet. And the specifics of who is on that committee is stated here. But it's not an ad hoc committee. It is a committee that is meeting on an ad hoc basis, which is different from an ad hoc committee. That is what my interpretation of this is, Mr. Speaker.
Very well. Yes, honourable member.
Yeah, thank you, Speaker. Speaker, my understanding of this committee is that it is ad hoc because any time they are finished with their work, that committee will be dissolved. But then it's telling us that any time that issue comes up again, we should go back and select the committee as prescribed here. That is it. So, I agree that this rendition should be like that. But the C, where my brother speaks about.
So let's resolve this issue.
Okay.
You have made me a member of a committee. Why will you dissolve that particular committee if the matter that you have given me, I have finished with it? I still belong to that particular committee. So in future, if there is any matter, then you refer it to the same composition. Yes.
The A, for example, is a rep from the Attorney General's department. So for the first committee, probably Dr. Kabiru is the rep from the Attorney General's department. When he's done with the work, that committee is dissolved. When a matter comes up again, that rep might not necessarily be Dr. Kabiru. It might be my good friend over there. So the ad hoc is the nature of the frequency the matter is referred to the committee makes it an ad hoc. Anytime that issue comes up again, we have to form the committee.
If you form a board, and you said that on the board is a representative of Attorney General's department. This is the word that we have been using when we are composing governing bodies. And we said a representative of the Attorney General's department not below the rank of a chief state attorney nominated by the Attorney General, who is the chairperson. Very well. Yes. Let me hear the Second Deputy Speaker first. I'll come to you, Honorable Soso.
We were thinking together. Probably, if we can do away with the ad hoc, well, that's my. Because it appears that the argument and the discussion is over around ad hoc. So if we can do away with the ad hoc and probably make the committee a permanent as part of the, then probably all this discussion will be situated well.
Yes, so the proposal is to do away with on ad hoc basis. Yes, let me hear Honorable Soso.
Thank you very much, Right Honorable Speaker. Mr. Speaker, I support the proposal that we do away with the on an ad hoc basis. Mr. Speaker, what this means is that the frequency of the meeting is an administrative process. So as and when it becomes necessary, referral is made to the committee. Now, the membership of the committee is statutory. So anytime the referral is made, the membership are put together to look at the issue. So I think that I really support the proposal that we do away with on an ad hoc basis, so that the rendition will read, the commission shall establish a compounding offences committee. Then the others can follow, Mr. Speaker. Thank you.
Yes, Honorable Dr. Kabiru.
Thank you, Mr. Speaker. Mr. Speaker, there are three things here. The first thing that I got from the chairman of the committee was the fact that the National Fisheries Association and that of the Ghana Aquaculture Association were ad hoc committees or association. That was the first thing I got. But now there are associations existing, and that hurdle has been passed. The second issue has to do with whether or not the established compounding offences committee is supposed to be ad hoc committee or a standing or select committee. From the framing of this particular bill, looking at composition, looking at function, it is not the intent of the drafter to make it an ad hoc committee. Because if it was their intention to make it an ad hoc committee, they will not go ahead to specify functions they are supposed to be doing, their composition, and even defining what compounding is and the processes. So, it is also clear that their intention is not to make it an ad hoc committee.
Right.
It is the sitting that they wanted to say they will sit on ad hoc basis. It is the sitting that they wanted to say that the committee will sit on ad hoc basis. So I agree that we would go with the amendments, expunging on ad hoc basis from it, and then subsequently amend E, C, so that the whole clause could then stand, Mr. Speaker. So, if it pleases you, we'll go ahead with it.
Yes, honourable members, I intend to flag this particular clause because the minister is not here to provide a policy guidance. We want to be guided. Yes, Honourable Hotoja.
Mr. Speaker, from my understanding of this issue, that the way they put this thing here, the commission shall establish, comma, on an ad hoc basis, comma, explains it all. This confirms the temporariness of the committee. So, as and when the issue happens, if it is aquaculture, they will pick members from aquaculture. And if it is fisheries, then members will be selected from fisheries. But the committee itself is a temporary committee and nothing more than that.
Yes, honourable members, I intend to flag this clause 144 so that we take it if the minister is here to provide a policy guidance. So accordingly, clause 144 is hereby flagged. We defer the clause so that we can all go and think through it. Yes.
Speaker, just one more comment. Speaker, I think it's an ad hoc committee. The fact that it's an ad hoc committee doesn't prevent the committee from having functions stated for them. So, Mr. Speaker, I suggest that instead of establish, we replace establish with constitute. Yes, so anytime there's a need to form that committee, it will be constituted instead of using the word establish.
So the minister would come and explain all these things, the policy rationale behind this. So, Chairman of the committee.
Mr. Speaker, if I may, we should leave it like this in the spirit of making sure that offenses in the fisheries industry are seen to be done with expeditiously. Because of that, the Commission is allowed to compose this committee, Compounding Offenses Committee, and the membership is such that they are carefully selected from the Attorney General, from a legal officer of the Fisheries Commission, and from the industry. So where it is marine-related case, it comes from the National Fisheries Association. Where it is inland case, the member comes from the Aquaculture Association. So for me, it's a matter of policy and it's straightforward. And so I don't see where the problem is here. Whether they are meeting on an ad hoc basis or they are standing, their essence, their object, is to be able to handle these compounding offenses. And the composition is so fortified to be able to do that. So, Mr. Speaker, I call on you to put the proposed amendment, in fact, there are no amendments, to put the current rendition, put the question, and then let's take a vote and move on. There's no need to flag it. Thank you, Mr. Speaker.
Honorable Dapamoko. if you are forming a committee with a permanent membership with stated functions to perform, is that committee ad hoc?
Speaker, even by our own rules, it cannot be an ad hoc committee. Ad hoc committees are set up to deal with matters, interim matters, and then their life comes to an end.
Yes.
So to that extent, okay, Chairman, let's flag it. Yes. Like the Speaker has directed. We deal with it. We can come back as second consideration to tidy it up, and then we'll take it. So, Speaker, we can make progress.
Very well. Accordingly, clause 144 is hereby deferred. Clause 145.
Functions of the Compounding Offences Committee.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Any proposed amendment to 145? Honourable members, yes.
Mr. Speaker, respectfully, I think 145 is emanating from 144. So if you are flagging 144, then yes, anything compounding committee should be flagged as well.
Thank you very much. Accordingly, 145 is also deferred. Honorable Sosu.
Yeah, Mr. Speaker, very, very respectfully, I propose that the 145 is clearly different. It's clearly different from the issues that we raised in 144 do not affect 145 at all. It only has to do with whether it should be an ad hoc committee or it shouldn't. But 145 is function. And Mr. Speaker, I believe that 145 as it is okay. There's no need for us to flag it, Mr. Speaker.
You see, honorable members, is it not the case that ad hoc committees normally work with terms of reference? So let's abide by what the minister is coming to say. Yes, Honorable Jerry Ahmed.
Speaker, if it flows that, then 146, 147, and 148. All of them, 149. 148, at least add up to 148.
Now, 146 is determining what will constitute the compounding offense. That one is not dealing with the committee and the functions of the committee. So when this offense occurred, then it will necessitate the formation of the committee to deal with it. So the terms of reference will be dependent on the kind of offense that occurred. Yes, Honorable Sosu.
Yeah, Mr. Speaker, I believe that in the rules of interpretation, it's so clear that we can glean the intent of the lawmaker from the law. There is no way you have these elaborate provisions in 145 and 146 and still be arguing that it's an ad hoc committee. It's not. So, Mr. Speaker, I believe that the House, even this House, Mr. Speaker, I believe that this House, which is a chamber that makes laws, has the power and the mandate to order that ad hoc basis out of the law, so that it will be consistent with the rest of the provisions, so that we will not delay the act, Mr. Speaker.
Yes, Honorable Chief Whip.
Mr. Speaker, that is why you directed in your wisdom that we should stand down 144, and we've established that 144, 145 147 and 8 are they are interlinked. So let's stand them down and do our homework. When we come back, it will be easy for us to take them. So, Mr. Speaker, they do not constitute a roadblock in making progress. So, Speaker, from what Honorable Sosu said, is the very reason why we should stand down these provisions. Then we can proceed with the rest. When the minister returns and we engage the table office, we can rehash the provisions to suit the interment of the House. Then we can take them, Mr. Speaker. Because the to and fro is still eating into our time.
Very well. Yes.
Mr. Speaker, no, Chief Whip, don't push me. Mr. Speaker, quite frankly, I don't know why we want to belabor this. I think Honorable Sosu's proposed amendment makes sense. So why don't we consider it and then make progress? It's a policy, straightforward.
Honorable members, we spend some time in this House when it is an issue bordering on policy. Sometimes we don't sit in cabinet, but the minister sits in cabinet. So the minister should provide us with some policy guidance. Then we can proceed. So accordingly, 145 is also deferred, as well as 146, 147, and 148. So we move to 149.
Fisheries and Aquaculture Appeals Committee.
Yes, Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Any proposed amendment?
Mr. Speaker.
Yes. Honorable Kabiru, then I'll come to you. Alaji.
Yeah, Mr. Speaker, I propose that since the Appeals Committee deals with Fisheries and Aquaculture Appeals Committee, 149.2b should have the rendition should rather be one representative of the fisheries of the fishing industry who is not an interested party in the subject matter of the appeal, nominated by the Fisheries and Aquaculture Association. And I make this mindful of the fact that 147, as I was proposing before the confusion, 144, see, because this is in reference to both fishing and aquaculture, and we cannot have only the explicit mention of the Fisheries Association in here. So we must either put both or leave it open as and when the case may demand, we'll select the relevant association. Thank you, Mr. Speaker.
Yes, Chairman of the committee.
Mr. Speaker, I think the proposal is okay. We can accommodate it. So if you can propose an amendment clearly, then we can adapt it.
Mr. Speaker, I'm proposing that we, under 149.1c, deletion.
149.2b. Yes.
2b. Deletion of National Fisheries Association of Ghana. And insertion of Fisheries and Aquaculture Association. And Mr. Speaker, I'm not using them in capital letters. I'm not using them in capital letters. Can I, maybe let me. So, Mr. Speaker, let me provide a bit of background. I am saying that I am contemplating that under in the interpretation section, we'll have Fisheries and Aquaculture Association. which you define to include the Standing Fishery Association and the Standing Aquaculture Association, and any other as recognized by the minister or by the laws of the country. That gives us room for the evolving nature of the industry. But if we have it as given that these are the only two associations we have, then I would propose that we say or I'll propose that we say National Fishery Association of Ghana or the National Aquaculture Association, as the case may be. So,
yes.
Speaker, before Chairman comes in, if we want to go by the present amendment by Honorable Kabiru, then you are leaving the discretion to the minister to do either or, and that can create that can create a confusion. Speaker, let me assist. The National Premise Committee is a committee that is constituted by representatives from fisher associations and canoe owners, both inland and marine. One of the fights we are engaging right now is that the associations, sometimes they split into splinter groups and they get registered and apply to the ministry for recognition. So one of the representatives of the National Canoe Fishers Association his status locus is being challenged by another group from inland as we speak. So once you recognize one association, we should be able to ensure that all the associations come under this national umbrella association. If you give either or, then because one association could continue to be a rep from one association could continue to be selected to serve on the committee to the detriment of the interest of the other association, which is an alternative. So as a house, our duty, some of these provisions exist in the previous laws, related laws. So going forward, I think we should be fine-tuning these provisions to bring clarity. Unless we want to enlarge the... Hello, let's have one discussion, please. Unless we want to, your proposal is that we should create another provision to accommodate the other association you speak of. Do you appreciate my point? But we cannot do either or situation in one provision. It may lend itself to abuse.
Yes.
Mr. Speaker,
I'll come to the two of you.
Mr. Speaker, the submission by the Chief Whip, Majority Chief Whip, is well understood. The problem is that the Act itself recognizes two associations. The Act itself recognizes two associations. And the first one recognized is the National Fisheries Association, and the second one recognized is the National Aquaculture Association. And if his submission is to anything to go by, there's still going to be that discretion. So we want to avoid this discretion to either say, keep it open so that he will either select from either the National Fisheries Association or National Aquaculture Association. That way, it makes the work of the minister easier. But if we put specifically the National Fisheries Association, when there are matters bordering on aquaculture, it will not be right. Because the heading of that particular section talks about fisheries and aquaculture appeals. So, Mr. Speaker, if we are agreeing that these two should stand, then I will just propose that we say or National Aquaculture Association, as the case may be.
So, Honorable Chairman of the Committee, how independent?
Mr. Speaker.
How independent is this particular appeal body taking into consideration clause 151? Because this is a body that will be presiding over a decision taken by the Commission or the Minister. and you want the minister's nominee to be here, and you are again saying that that should be the industry player who is not affected by the subject matter. Yes?
Thank you, Mr. Speaker. Mr. Speaker, there's even a bigger problem with the clause 149. Clearly, clause 1492, the committee consists of, and then 1492A, a representative of the Attorney General. And then we have the B, a representative, and we have the C, a person nominated by the minister. But when we look at 3, the minister shall appoint members of the appeals committee. So the issue now is, which members out of 2 will the minister appoint? So we need to look at even the 3 as well. Because if you are saying that these are going to be the components of the committee, the appeals committee, you cannot say that the minister would also go to the Attorney General's office and appoint a representative to come and serve on the committee. So that is my
member,
challenge.
I think I'll have to engage you. I'll have to engage you. The board members, they are nominated from various institutions. But at the end of the day, the president will have to appoint all of them. That is the same principle here, that after composing the members of the board, they must be appointed by the minister. So it doesn't mean that if the Attorney General nominates, that nominated person will not be appointed. The nominated person will have to be appointed.
Mr. Speaker, thank you. But in
You,
the
you are a
there was
member of
similar
parliament.
provision.
You are a member of parliament. But if you are nominated by parliament to represent on a board, won't the board members be appointed, including you?
Wording here, you see the wording here, the minister shall appoint members of the appeals committee sitting on its own. You see, it's not making any reference to 1492.
No, you read the provisions as a whole. You don't choose. So
There's a
2
similar
is telling
one
you
in the
that
Board's board.
this is how
Open
the committee will be composed. Then after the composition of the committee, then the minister will go ahead and appoint the members of the appeal committee as composed in 2. I think this is a standard provision.
Mr. Speaker, I'm taking a cue from the goals board. See, when you go to the goals board, there's clearly this similar provision there. But what it does is that the president shall appoint the chairperson and other members. You see, it specifies the person that the
But
minister
read
will appoint.
2A. 2A is telling you that one representative of Attorney General's Department not below the rank of principal state attorney nominated by the Attorney General, who is the chairperson.
That's a rep. It's not somebody that the minister
But
will
whoever is the rep will not act as just a member, but he will chair because of the legal background. So there is no room for the appointment of a chairperson again.
No. I think we are talking about 2 different things, but then I stand to be guided. What I'm trying to say is that, would the minister have the discretion not to accept the representative from the Attorney General? That's one question. And the representative from the fishing industry, that's another question. If you say that he's going to appoint them, then it means that he has the discretion not to include them.
No,
So if
look at the rendition. The minister shall.
yes.
So shall, does it give discretion?
No, appoint.
No, but you can read appoint in isolation. It said the minister shall appoint. So it doesn't give discretion to decide that I'm not going to appoint or I would appoint. So there is no element of discretion here. Or the lawyers, does it give a discretion? There's no discretion.
The bracket from which he can appoint from, that is where you would have the flexibility.
It means that if all these are composed, 2A, B, and C, then the obligation is imposed on the minister to appoint. You don't make a choice. That's why they say, they didn't say the president, the minister may appoint. So in this case, because they use the word shall, the composition is binding on the minister to appoint. Yes, Honorable Sosu.
Mr. Speaker, I perfectly do agree with you, except that I want to make a proposal for the 2B to clarify the issues that our colleague brought out earlier. So that I propose that the 2B now reads, one representative of the fishing and aquaculture industry nominated by the National Association of Fisheries Association, National Fisheries Association of Ghana, or Aquaculture Association, as the case may be.
No, your rendition would rather make it complex. It's for a stated reason. That is why they say that the person should not be an interested party in the subject matter. So I think this issue crop up, and that was a proposal. So all we need to do is to delete the, to say nominated by the National Fisheries Association of Ghana or Aquaculture Association of Ghana, as the case may be. That's the proposal.
Mr. Speaker, I'm aware that the use of "or" in the drafting language, whether it's appropriate, you have.
So it means that here "or" is disjunctive, meaning that between the Fisheries Association of Ghana and Aquaculture Association of Ghana, the nomination is either done by the Fisheries Association of Ghana or aquaculture. You understand? So the problem we are giving them is how they will come together to say that this person should do the nomination or not this person. That is the problem we are giving them.
Yes, Speaker,
yes,
the
Honorable Majority Chief Whip.
Okay. So, okay. Speaker, the purpose for this provision is to suggest that depending on the nature of the matter, the subject matter of the decision that is coming on appeal, if it's related to inland fishery matters, then the rep from the Aquaculture Association would be nominated. If it's about marine, then National Fisheries Association. But the question, the issue you raised, which is that under 151, the decision of the commission or the minister, if somebody is aggrieved, is what will come on appeal under 149. So I agree with you that the minister shouldn't have the power to nominate, to have a rep here under his or her direct hand. So, Speaker, to cure that mischief, if the House will go with me, we give that power, an additional power to the AG, so that instead of making one nomination, he makes two. Because the provision gives him the power that whoever he nominates becomes the chairperson of the appeals committee. So we give the power to AG to nominate two persons. One becomes the chair. Then B, the other members of the committee will reflect the nature of the subject matter to be nominated by these associations. Then we delete C. We delete C so that when it's agreed, then the minister will merely go ahead and issue the appointment letters to these persons to go and proceed to hear the appeal. If the House appreciates what I'm saying.
Yes, Honorable Jerry Ahmed.
Yeah. And Speaker, let me add this. For some time now, we all gloss over it. Normally, when we give public servants opportunity to make the nomination, we endeavor that they include women, so that the power to nominate one should necessarily be a woman, so that affirmative action will be carrying the woman along. We've been doing that. If you give the direction, then the two persons to be nominated.
Yes, let me hear Honorable Jerry Ahmed.
Great.
Speaker, I agree with my
Honorable nominee, I'll come to
my colleague I think C should be deleted, especially in pursuant of what you raised. But my consideration is that we should look at B and make B representatives of, so we are looking at 2, representatives of the fishing industry who are not interested parties in the subject matter of the appeal, nominated by the National Fisheries Association of Ghana and the Aquaculture Association of Ghana.
Well, Honorable Dr. Grace.
Thank you, Mr. Speaker. Mr. Speaker, I would like to beg your indulgence on this. I'm wondering if we can use the omnibus clause to fix this problem, where you leave it open for future, because you know aquaculture industry is also developing. So maybe other agencies or associations might spring up under the aquaculture heading. So would an omnibus clause fix this problem that we're trying, or cure the problem? Thank you.
Who will have the omnibus power?
Well, Mr. Speaker.
Is it the minister or the commission? But you are saying that the minister should not even nominate one person. Then you want to give the power to the minister again to exercise under the omnibus. Yes, Honorable Kabiru, I'll come to Honorable Soso.
Mr. Speaker, I think we have 2 issues on the board, and we'll have to address one and move to the next one. The issue raised by Honorable Raphael is to the effect that the power of the minister to nominate, which brings into issue of the ability of the committee to have oversight in terms of appeal. And the second issue has to do with the B.
No, he is raising issue with 3.
No, that is 3. Sorry,
yes.
3. And the second issue has to do with 2B, which I raised. And I think that if we bring closure to...
I think his issue is no issue.
Yeah, okay.
What is the issue is now
2B.
C and B.
Okay, so...
Whether the minister should have the power to nominate.
Yeah, so...
And then the B.
Mr. Speaker, the B, let me propose this, and whether you can put that so that I'll propose that one representative of the fishing and aquaculture industry, and I repeat, one representative of the fishing and aquaculture industry who is not an interested party in the subject matter of the appeal, nominated by the National Fisheries Association of Ghana or the National Aquaculture Association of Ghana, as the case may be.
You see, when we were passing one of the bills, the teacher, the university associations, and then they put them together to do a nomination. They came back to say that, if you recall, that there is always a struggle as to whether the nomination should be done by TEU or the nomination should be done by this. So it's a real difficulty, and that is what we are trying to cure.
Speaker, that is why I agree with you, because that would bring, we have dealt with these fisher folks over the period, and we know that the moment you say it's coming from this place or that place, it would cause more problems. That was the reason why I made the proposal that we should consider the 2 instead of Roxin's request or submission that we should go and bring an additional person from AG. We should get both aquaculture and whatever we have already captured, the National Fisheries Association, the 2. So we still delete that C, that would give the minister the power to also nominate or appoint. So that at all times material, you have someone, both people with expertise.
Yes. So let's deal with this proposal. So are you dealing with this particular proposal?
Yes.
Yes.
I believe that, Mr. Speaker, if we take a cue from what Prof has said earlier, it probably will resolve this, because it is possible for us to use nominated from the association and define association in the definition page to include the various forms of association that we have.
You see,
that way we can resolve.
in drafting,
Yes, Mr. Speaker.
you try to cure a mischief that the law is likely to cause. Mostly by experience, when you put two associations together and you ask them to bring one nomination, there is a struggle as to whether the person to be nominated should come from A or B. So they have a difficulty getting a representation. And without their representation, you can compose the committee. So having that at the back of mind, why do we give this problem to the Fisheries Association of Ghana and Aquaculture Association of Ghana that the two of them should come together to do one nomination? So how do we cure that particular problem?
Mr. Speaker, that wasn't the. Mr. Speaker, that wasn't it. Actually, my understanding is that the National Fisheries Association is definitely different from the Aquaculture Association, and that depending on the subject matter, the Fisheries Association will nominate, or the Aquaculture will nominate. So it's not the case that both the Fisheries Association and the Aquaculture Association come in together to nominate one person.
No. You see, this is an appeal board that is being composed. So it's not that as and when the situation may be, you remove this person and bring another person. That is not my understanding.
Yes,
You understand? It's like a disciplinary committee, like composing a disciplinary committee. They are not going to sit on one issue and then they are dissolved.
Mr. Speaker, that being the case,
So I am inclined to go with the proposal by the Deputy Minority Whip, so that once we agree that we have to take out C, then we end the rendition to be one representative of the fishing industry who is not an interested party in the subject matter of the appeal nominated by the National Fisheries Association of Ghana. Then the C will again be one representative of the aquaculture industry who is not interested in the subject matter of the appeal nominated by the Aquaculture Association of Ghana. Period.
Yes, there is.
Yes, let me hear the senior first.
Speaker, you are right, and that is an enhancement of Honorable Ahmed's proposal. So we take away the power from the minister to make any nominations, because this committee will be revealing her decision if somebody is aggrieved or a party is aggrieved or the commission's decision. So Jarish will own it, then we make progress. We've spent too much time on this one.
So, own the proposal.
Yeah. It's okay.
Yes. Yes,
Speaker, my humble position is that you have enhanced Honorable Ahmed's proposition. So he should own it. And then we take it, then we can make progress. We spent too much time.
Very well.
On this
Very well, yes.
Just a quick contribution. We are dealing with these people because of the expertise they are bringing on board at the appeals committee. But clearly, you can't hear me. I'm saying that, Mr. Speaker, it is to do with the expertise that members from these associations will bring to bear on deliberations at the appeal level. But clearly, that has already been taken care of in the Act 1495. The appeals committee may co-opt an expert. And then if you're dealing with expertise, that's an expert, to attend meetings of the appeals committee, but that co-opted member shall not vote on a matter for decision at the meeting. So we can actually
member,
do away
I
with
don't
the
think we
entire...
are speaking with specific reference to the mischief that we are trying to cure. The mischief that we are trying to cure is that Ghana Fishing Association is one body. Then the Aquaculture Association is one body. Now, how to put the two of them together to bring one representation will be problematic.
I agree.
So therefore, we should give them a representation each. How does the co-option address this particular issue? The status of a co-opted person. Listen to me. The status of a co-opted person is not the same as a member of the committee. A co-opted person does not have a right to vote.
What I'm saying is I am proposing a total deletion of that clause because I don't see...
Which clause?
The clause 2B, 1492B, the one that there is...
so if you delete it, the person from the Attorney General's Department will have to sit alone and constitute appeal.
No, there's other members to be appointed by the minister.
No. Yes, we need to make progress on this issue.
Sorry. Initially, when I rose, I had a minor correction to make, and it has to do with a typo. So if
What
I can just
will
bring
happen
that
is that when there is an issue, honorable members, when there is an issue, we resolve it.
Mr. Speaker, then let me speak to that issue.
To another issue.
Mr. Speaker, then let me speak to that issue.
Very well.
Let me speak to that issue.
If it is not on the amendment at stake, then don't take us to another issue.
So, Mr. Speaker, on the issue of the composition of the appeals committee,
yes, you have the floor.
Mr. Speaker, on the issue of the composition of the appeals committee, Mr. Speaker, I was just asking the chairman of the committee why they seem to have totally departed from the norm, especially in the establishment of appeals committee. Because if you look at the Electronic Transactions Act and you look at the Gold Boss Act, both have appeals committees, and the way the committees are composed of entirely different from this. So when we were considering, for instance, the Gold Boss Act, we didn't even spend a minute on the composition. And I'm sure same was in the case of the Electronic Transactions Act. But if you look at this, because those ones, they give the power...
So, honorable member, guide us as to how the composition
so, Mr. Speaker,
should be.
let me first of all refer to how the Gold Boss Act couched their appeals committee, and then I can come to the Electronic Transactions one. Mr. Speaker, sorry. Section 56, composition of the tribunal, that is, this is in respect of the Gold Boss Act. The tribunal consists of a chairperson that is, the tribunal consists of a chairperson who is a retired justice of the Superior Court of Judicature, or a lawyer with at least 15 years experience in the regulation of the gold industry or the practice of alternative dispute resolution, and B, 2 other members with expertise in minerals and mining law or commerce. Then they say the president shall appoint the chairperson and other members. Now, in the case of the electronic transaction, it also has the same line of composition, but in that one, they say the Public Services Commission shall appoint the members. And so when you leave it like this, Mr. Speaker, I think you cure the issue of who should be represented, who should not be represented. Mr. Speaker, that also comes to address an issue, a very vital issue you raised. Because if I have a rep of an association sitting in the appeals committee, any member who is aggrieved by the decision of a minister will definitely be a member of this association, one of them. And so the leader of the association who is represented in the appeals committee will definitely be seeking to further the interest of the member who is disgruntled. And so how do you cure that? By bringing members of the association to serve on the appeals committee. To me, the two associations should be left out of the whole discussion, because each of them will be furthering the interest of their members. Respectfully submitted, Mr. Speaker.
Honourable members, with all due respect, this boils down to the independence of the appeal committee, as I raised earlier, because matters that the commission or the minister will be taking decision on would emanate in one way or the other, either from the fishing or aquaculture. Now, you are again saying that when that matter goes on appeal, respective members of those associations should go and sit on the appeal. So, a situation where a minister has taken a decision, and then you have a member of those associations going to reverse the minister's decision. A commission has taken a decision, and then you have members of the association going to reverse the decision. You understand? So for me, it's a problematic. So can we adopt the rendition in the gold board so that it will allow maybe a lawyer of a minimum experience in the industry to be appointed in addition to the chairperson from the AG's department, and then at least a woman with a knowledge in the industry to also be appointed to be the three to sit on the appeal. Yes, Honorable Sosu.
Yeah, Honorable Speaker, I share in that thought. However, you know, laws also emanate from practice. So currently, what is a practice in the fishing industry? So this may go back into policy. That is what I think. Unless you have some further explanation from the minister in respect to how they resolve issues as and when they come before them currently. I believe that maybe this rendition may be based on industry-specific practice, which may be a little bit different from what may be happening with the electronic transaction as well as the gold board. So that is what I think about this one right now, Mr. Speaker.
I will take one more contribution and then we'll decide the way forward. Yes, Honorable Kabiru.
Mr. Speaker, I'm also persuaded by your statement and that of my colleague from Yendi. Safe to also concur with Honorable Susu that if we truly want to have an independent appeals board or appeals committee, then even the nomination from the minister will be questioned and every other thing. So I'll suggest that we defer it back to the minister and then the drafters to tidy it up.
Honorable, we agree that we can give that power to the minister to nominate somebody to sit on his own appeal.
Agree.
So we have crossed that particular hurdle.
Yeah, Mr. Speaker, I'm not saying that they should nominate. I'm just saying that that and many other issues are coming up. And I was just suggesting that if the legislative drafters could look at it.
So, honourable members, can we adopt the rendition in the gold board? Yes, Honourable Jerry Ahmed, and then I'll come to the chairman of the committee.
Speaker, I would have agreed with you that we should agree with the rendition in the gold board, save that, like Honourable Susu said, with fisheries, the expertise are a bit different. And therefore, the only part that I think you have made a statement on and we should consider is the appointments by the minister. But besides that, we can look at some of the people that, or some of the bodies that we have indicated here already, like the National Fisheries Association of Ghana. We need them. We need the aquaculture people as well. Then we can do a hybrid of what is in gold board and here. And I'm sure that would be better.
You see, Honorable Jerry Ahmed, these are associations working under the commission. You understand? A commission has taken a decision. The body that should sit to uphold or reverse the decision of the commission must be a higher body. Now you are picking from, you understand, the association to come and preside over appeal of the commission. So that is where the difficulty is. So we can be guided this way. We maintain the A. We maintain the A. Yes, so that whoever is coming from Attorney General's department will be a chairperson. Okay, and then the B. Then we said a lawyer of maybe 5 years standing at the bar with experience in fishing and aquaculture. Then we say C, a woman with a knowledge in fishing and aquaculture. Then that's what the drafters can put it nicely for us.
Mr. Speaker, I agree with the principle, and that this appeals body should be independent and should be seen to be independent. Reps of the associations may introduce some biases. So to that extent, I agree with the application by my colleague from Yendi. However, I want to draw attention that, you see, in practice, these disputes in that industry are settled in informal ways. You know, it is settled in informal ways. Then two,
Honorable Chairman, Honorable Chairman.
Just one more. Two, we have knowledge institutions such as the EPA, Water Resources Commission, and related bodies, GMA, Ghana Maritime Authority, that may be useful in providing information and expertise that can help in the appeals process. So in considering this composition, in line with the proposal from the honorable member from Yendi, I think that we should avail our minds to these expertise that will be useful in settling the appeals cases. Mr. Speaker, I so submit.
Yes, Honorable Jerry Ahmed.
Speaker, I don't know the general constitution of the Judicial Council, but I also believe that there are judges on the Judicial Council. Would that respectfully mean that because they are judges, they will definitely... Speaker, who is going to appoint...
Well, in this case, the Judicial Council, they hear matters. It's not on appeal. But this one, we are talking about appeal against a decision of a minister. That is why the issue of settlement of the dispute does not come in. Because for there to be settlement, it will come in before a decision taken by the minister. So if you are aggrieved by the decision taken by the minister, then you are appealing against the decision of the minister.
Speaker, that is where I agree with you on all of that, because I understand that you don't want us to have a judge in its own course. But who is going to appoint the lawyer of 5 years standing? Who is going to appoint all the members therein? Who is going to appoint them, Speaker?
Honorable Jerry Shaib, the judges who appoints them is the president. So in this case, we can decide that they are also appointed by the president or they are appointed by the minister. Yes. Honorable
Speaker, you are an advocate for consistency as a house, how we draft certain provisions that feature commonly in legislation that we pass. This is one of them. Speaker, I am looking at the Standards Authority Act that we passed recently. Speaker, indeed, 2022. It's not too old. Speaker, this was one of the elaborate laws that we passed. And under Section 40, so myself, listening to the arguments, I am beginning to appreciate why we even want to establish a separate committee, appeals committee. Because I checked the NACOC Act, I check the OSP, all those things, we give it to the board. When there is an appeal against the decision of, these are administrative decisions. When somebody is aggrieved, then you appeal to the board. Then under the Standards Authority Act, we give the mandate to the board to set up an appeals committee within a certain number of days upon receipt of the complaint. Then we give the board the mandate to make appointments of members of the board from within the board. So, for instance, under Section 40, this was what this House did in matters of this nature. Speaker, it says appeals against decisions of the authority. 41. A person dissatisfied with the decision of the authority may appeal to the board against the decision. 2. The appeal shall be made within 21 days after the appellant has been informed of the decision. 3. The board shall, within 28 days after the receipt of the appeal, set up an appeals committee chaired by a member of the board to determine the appeal. 4. The appeals committee shall, subject to the rules of natural justice and all that prescribed by the regulations, determine the procedure of the appeals committee. 5. The appeals committee shall determine an appeal within 21 days after the submission of the appeal and may affirm the decision of the authority, vary the decision of the authority, or revoke the decision of the authority. A person who is dissatisfied with the decision of the board may apply to the High Court for a review.
Yes, but the difference here is that in this particular case, in the bill that we are considering, decision of the minister is being appealed against. So you cannot refer a decision of the minister to a board committee to reverse.
Speaker, that is why I think that we should stand this down as well. No.
Very well.
Yes,
very well. If that is the pleasure of the House.
And engage the minister and the drafters so we can disaggregate and fine-tune it.
Clause 149
we should
also
borrow
deferred.
from other provisions to simplify the matters. I think so, Mr. Speaker.
Clause 150.
Oh.
Tenure of office of members of the appeal committee. Yes?
I was having something to do. It's just a typo so that we can correct it.
Clause is deferred. We will not take any further contribution on it. Clause 150.
Tenure of office of members of the appeals committee.
Yes, Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Yes.
Mr. Speaker, with 150, the term of a member of the appeals committee shall hold office for a period of 3 years. I'm proposing that since if you go to 8, clause 8, the term of office of the members of the governing board is for a period of 4 years. So for consistency and the term of office of the committee, that will be working along the same line.
No, in these matters, we must avoid a situation where all of them are going in block.
Yes, so here he's saying for a period of 3 years.
Yes.
Whilst that of the governing board for a period of 4 years.
Yes, so if the government board is 4 years, it means that at the time that some of the appeal members will be going, the board is still in existence. Then another appeal board comes. Then members of the board goes, so that it won't appear as if the board term has ended, the appeal committee, the term has also ended. That is why there should be some differences. Honourable Member, you are not getting it.
Yeah, I do get it, Mr. Speaker. In that case, then we could increase it to 2 more terms so that we can have an overlap. For if in case a board member is there for 8 years, we can have an overlap. We can have an overlap of
you see,
9 years.
For instance, the board has a tenure of office of 4 years. If you want this appeal committee to also have a tenure of office of 4 years. It is possible that at the time that the board is going, the term of the appeal has also ended. You understand? But they don't want it to be coterminous. Honorable Chair, you are not getting the point.
Mr. Speaker,
let's say you are a member of the appeal. I'm a member of the board. So at the time that your tenure of office has ended, my tenure of office have not ended. So if you are eligible, then there will be re-election. So at the time that my tenure of office as a board member has ended, the appeal board is in place. So if you make it coterminous, do you understand this?
Mr. Speaker, I agree, but in agreeing today, that's why I'm suggesting instead of one more term only, then we can add 2 more terms.
We have never gone beyond 2 more terms before. So the tenure of office is eligible for another term only by practice and in all laws. Any further question? Honourable members, as many as are in favor of clause 150 standing part of the bill, say aye. Those against say no. The ayes have it. Clause 150 is ordered to stand part of the bill. 151.
Appeal from decision of the Commission.
Yes,
Mr.
Chairman
Speaker,
of
we
the
have
committee.
no advertised amendment.
Yes, it is for the consideration of the House. Yes.
Mr. Speaker, 1515. A person who is not satisfied with the decision of the Appeals Committee may, within 60 working days, I want to propose that we leave it at 60 days, not working days, to avoid the computation.
Yes. Yes.
Speaker, I support the present amendment.
Very well. Is that the sense of the House? Honourable members, is that the sense of the House? So the proposal is to delete working.
That is so, Mr. Speaker.
And consequentially, as many as are in favor of clause 151 standing part of the bill say aye. Those against say no. The ayes have it. Clause 151 as amended in 5 is ordered to stand part of the bill. Clause 152.
Information or documentation to be true, complete, and correct.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Any proposed amendment? As many as are in favor of clause 152 standing part of the bill say aye. Those against say no. The ayes have it. Clause 152 is ordered to stand part of the bill. Clause 153.
Willful damage to fishing vessel, gear, or other fishing appliance.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Any proposed amendment? Yes.
Mr. Speaker, I was going to
Honourable member for Yendi.
Mr. Speaker, I was going to suggest that if you read 1531, a person who willfully damages or destroys a fishing vessel. Mr. Speaker, in law, it's always safe to use negligently as well when you are going with willfully. Because someone may damage another person's vessel, but not willfully, but negligently. So would the person be allowed to go scot-free?
Honourable member, your proposal is right. I have litigated in this House as to whether we should be legislating, creating offense, saying willfully. Because already the law says 2 things constitute a crime, the act and the intention. So for me, the proposal would have been to delete the word willingly. So the rendition will be a person who damages or destroys a fishing vessel, gear, or any other fishing appliances which belongs to another person, commits an offense, and is liable on summary conviction. Then the rest of the renditions will follow. Yes?
But, Mr. Speaker, the problem is there should be, when we leave the rendition like that, then the menstrual is a little bit missing. Because if you simply say that a person who damages, the damage could come inadvertently.
So I can engage you as a lawyer. If somebody steals, you understand? They say stealing, you commit an offense. Does it mean that willingly stealing is not there, the mens rea is taken? It's something that is already embedded in the commission of a crime.
Mr. Speaker, I perfectly agree.
So the element of the intention, whether it is stated expressly or not, for you to succeed in convicting somebody, you must prove the intention. You can't just prove damage without the intention.
But, Mr. Speaker, the challenge here is that, well, very well, I think I would defer to you, Mr. Speaker.
Yes.
Speaker, I'm not sure if we have really considered the meaning of willful. It doesn't mean that it's not intentional. Speaker, if you read what it means, it says that done intentionally. Willful means done intentionally or determined to do exactly as you want. So willful should be there. It doesn't take anything away. It actually says that you did it intentionally. The moment you change it, it will rather change. Speaker, I don't know if you were listening.
I'm listening to you very carefully.
Speaker, I am saying that if I've just looked at the Cambridge Dictionary and we are supposed to look at the word willful.
Yes.
Speaker, I
What's
know
the
that
meaning of
your
willful?
view is that.
What's the meaning of willful?
It says done intentionally.
Yes.
And
that is the meaning of willful.
Yes.
And my point is that for every crime, there must be an element of intention. So when you leave the willful here, you mean intentionally. Because nothing is a crime if the intention is not there. So what is this done intentionally doing? Is it serving a purpose? Because already, if, for instance, if you are taking me to court that I damage or destroy a fishing vessel, unless you are able to establish that that damage is intentional, is done intentionally, is done willfully, you cannot sustain a conviction against me. Do you understand? It's already an element that you have to prove. It's one of the ingredients.
Speaker, but there are instances that damages are caused not intentionally.
So when it is caused not intentionally, it cannot be willfully.
Well, but it's just reiterating the point that this was intentionally done. This damage was intentionally done, and that is why it amounts to crime.
Yeah.
Yes.
Mr. Speaker.
Yes, Honorable Sosu.
Yeah, Mr. Speaker. Very, very respectfully, I believe that the rendition would not lose anything if we were to leave willfully there. Now, what it means is that, like you rightly said, it means that it imposes a double obligation. That is what it is. First of all,
Well, I will have a difficulty creating an offense that will impose double obligation. Instead of the general principle that single obligation is imposed.
Yeah, but Mr. Speaker,
don't do this. You've done it. Once it
Speaker,
is established.
Yeah, but Mr. Speaker, what that means is that I'm sure that at sea, a lot of things happen at sea. People may deliberately want to cause damage to people's vessels for their own intended purposes. What the law is saying is that beyond the fact that we know that when you cause a damage, the damage could be either intentional, unintentional, it could be negligent, or whatever it could be. The only time that you carry a criminal conviction is when it is willful. In other words, there's an extra responsibility.
Tell me an instances where a criminal conviction is carried if the act is not done intentionally. Just one instance.
Well, there is no instance like that. But Mr. Speaker,
There is no. So you agree with me? There is no instance like
no,
that.
But Mr. Speaker, my issue is that.
So Honorable Sosu, the word here is much ado about nothing.
By emphasis, by way of emphasis.
I want to give you an instance.
Yes.
Somebody throws a stone.
Yes.
Hits your windshield. The stone was not directed at you. The person is 18 years and above. They were having some sort of argument. And then the person is arrested. And the person is prosecuted. Speaker, the stone throwing was not directed at your car. But it has caused the damage. Which damage was not intentional.
Yes, so when the damage is not intentional, the person have not committed any offense.
He has, Mr. Speaker.
That is what it means in law.
He has.
Speaker, the person has committed an offense.
No.
The police has even arraigned the person before court.
No. You see, the police can arrest you on suspicion. But when you are taken to court and it is established that your act is not done intentionally, then it will not constitute an offense. There is an act, but the intention is not there. So why do we say two things constitute an offense? Both must be present at the same time. Yes, but what is the sense of the House? So I've heard you a lot on this issue. Yes, Honourable Member.
Mr. Speaker, I want to draw your attention to Section 11.
Please, I've given the floor to him.
Yeah, I will draw your attention to Section 11 of Act 29 that defines intent. That when a person does an act for the purpose of causing an event, he will be deemed to have caused the event, whether in fact or indeed he intended to commit that event. So there are general provisions on intention. I believe that this one's perhaps just is stretching it further, that beyond the general provisions.
Honourable Sosu, in crafting law, you can craft the law, which is a criminal offense, and do away with the Criminal and Other Offences Act as well as the Criminal Procedure Act.
Well, Mr. Speaker,
you must just oppose it.
Mr. Speaker, I defer to you on this.
Yes.
one.
So, yes.
Thank you, Mr. Speaker. Indeed, it is not every offense that you must establish an intention. Mr. Speaker, in the offense of murder, when there is no intentions, it becomes manslaughter.
Yes.
So clearly, your rendition that we should do away with the willful, what it will mean is that you can be caught by this act if you are reckless, and at the same time, if you did it willfully. So if it's either we are deleting the word willful or adding reckless to it.
Honourable Member, what it will mean is that if you are reckless, that is negligence, and negligence is in civil realm. But here we are creating a criminal offense for which the punishment is imprisonment or fine. Do you understand?
Reckless person is not negligence. Reckless is punishable in law, in criminal law. That is why you will be convicted for manslaughter. Otherwise, you can never be convicted for manslaughter. Manslaughter, you must establish recklessness, not intentions. So clearly, recklessness does not defer you
Honourable
to
Dr.
civil
Kabiru
realm.
wants to help you.
Mr. Speaker, Section 11 of the Criminal Code states that every man intends the probable and natural cause of his action, and is given. And so once you intend the natural and probable cause of your action, intention can be presumed until the otherwise. And I think that if the law creates an act as an offense, it is for us to assume that anyone who commits it intended to cause that particular act. If you act willfully, then you must go ahead to provide that the person actually knew it was a crime. He wanted to do it. He took positive action to do that particular act. So I think that we should leave it without the willful act of the person. Let's just create the crime, the punishment, the liability, and there is it, Mr. Speaker. Thank you.
Honourable Dafonko.
Speaker, I've listened to all the views, and I think the problem is from the head notes, and that is all you are against. So the controlling adjective there should go away.
Yes.
The willful should go. What are we saying? Damage can be caused to vessels. Damage can be caused to fishing gear. But it can also be done under lawful authority. So what this House wants to do is to say that, so I propose that we delete willful and insert unlawful damage to fishing vessel, gear, or other fishing appliance. Then in the body of the provision, Speaker, we commence by saying 15311, a person who unlawfully damages or destroys a fishing vessel, gear, or any other fishing appliance which belongs to another person commits an offense and is liable on summary conviction. Speaker, when you were here, you one day argued that summary conviction means the person will go through the rigor of trial, at which trial all the elements of the offense will have to be established. So there's no need for us to insert willful, because that is why the law is saying that upon summary trial, the person is liable on summary conviction. Summary conviction means trial has occurred, evidence has been led and recounted, the court has come to a determination and convicted you. Then,
you see, honourable members, the difficulty that I have is legislating on ingredients that you have to establish in law.
I agree.
If you look at our Criminal Offences Act, it is there, stealing, underline. They didn't say unlawful stealing. So the offense is stealing. So this one, it will be damage to fishing vessel, gear, or other fishing appliances. Then when you come to the body, then you said a person who damage, destroy a fishing vessel, gear, or any other fishing appliances which belongs to another person, commit an offense and is liable on summary conviction. Because it is only when you are liable, and for you to be liable, they must establish that you have done the act was done intentionally, which is willfully. So we can delete the word willful in the head note as well as in the provision.
Yeah, so, Mr. Speaker, I support that the proposal that we delete willfully from the provision.
Yes, honourable members, those in favour of deletion of the word willfully in clause 1531, say aye. Those against say no. The ayes have it. The amendment as proposed by Sosu is carried out. Then the head note. Yes, the head note. Those in favour of the word willful being deleted from the head note, say aye. Those against say no. So I will then put the question on clause 153 as variously amended. Those in favour say aye. Those against say no. The ayes have it. Clause 153 is ordered to stand part of the bill. Clause 154.
Unlawful import of and export of fish.
Yes, honourable members.
Mr. Speaker, we have no advertised amendment.
Honourable members, it is for the consideration of the House. As yes.
Speaker, with respect, I observe that subclause 1, as we have it currently, is incomplete in rendition. If you may, Speaker, a person shall not import into or export from the country fish in commercial quantity unless the person has been granted a permit by the minister or on the advice of the commission. Speaker, the reference to fish alone over here, when you go to clause 156, you notice that reference has been made to export of fishery products, fishery or aquaculture products. And so I wish that just so we be consistent and not to create a lacuna, we insert fishery and aquaculture products just after fish. Thank you.
Yes, Honorable Majority Chief Whip.
Speaker, the present proposed amendment actually enhances the provision. So I agree with it.
Yes, Chairman of the committee.
Speaker, I'm helping the chairman in his absence. So I believe that it also brings consistency to the phrases that we employ. Speaker.
So reference was made to which clause?
Speaker, clause 156. 156(1) in particular. A person who imports, exports fish, fishery, or aquaculture products shall 154. Okay. So instead of fish, we add fishery and aquaculture products as contained the head note of 156, Mr. Speaker. So we have fish, fishery and aquaculture products. I thank you.
Very well. I intend to refer to the drafters to tidy it up. As many as are in favor of clause 154, as referred to the drafters to be tidied up, say aye. Those against say no. The ayes have it. Clause 154 is ordered to stand part of the bill. Clause 155.
Unlawful interference with aquaculture establishment.
Yes. Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. As many as are in favor of clause 155 standing part of the bill, say aye. As many as are in favor of clause 155, say aye. Those against, say no. The ayes have it. Clause 155 is ordered to stand part of the bill. Clause 156. Chairman of the committee.
Speaker,
yes?
just hold on. Speaker, just by way of, because this is, we learned it from you. Speaker, you will note that the head note of this provision, they simply, the 154 that we just carried, they qualify it with unlawful, not just interference, but unlawful. It's similar to the one we considered under 153.
Yes, look at 151, the rendition as they captured it, and 153.
And then 154.
And see whether it is one and the same.
Speaker, they are similarly couched. They are looking at the unlawful conduct.
No, if you look at this, they say a person shall not,
yes,
without valid and applicable aquaculture license.
Yeah, that is like
so
unlawful
this one,
authority.
So this one envisage a possibility of lawfulness. That is why they capture this particular rendition this way.
All right.
Yes.
Unlawful interference with aquaculture establishment.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. As many as are in favor, say aye. Those against, say no. The ayes have it. Clause 155 is ordered to stand part of the bill. Clause 157.
155.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, the question is as many as are in favor of clause 157, standing part 156, standing part of the bill, say aye. Those against, say no. The ayes have it. 156 is accordingly ordered to stand part of the bill. 157.
Authorization for transshipments.
Mr. Speaker, we have no advertised amendment.
It is, however, for the consideration of the House. Any proposed amendment to 157? In the absence of any proposed amendment, the question is as many as are in favor of 157 standing part of the bill, say aye. Those against, say no. The ayes have it. Clause 157 is ordered to stand part of the bill. Clause 158.
License and landing requirements for transshipment and export of tuna.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Any proposed amendment? In the absence of any proposed amendment, the question is as many as are in favor of clause 15A standing part of the bill say aye. Those against say no. The ayes have it. Clause 158 is ordered to stand part of the bill. Clause 159.
Prohibition of licensed fishing vessel from landing fish outside the Republic.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Any proposed amendment? In the absence of any proposed amendment, the question is as many as are in favor of clause 159 standing part of the bill say aye. Those against say no. The ayes have it. Clause 159 is accordingly ordered to stand part of the bill. Clause 160.
Possession of prohibited fishing gear.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Honourable members, in the absence of any proposed amendment, the question is as many as are in favor of clause 160 standing part of the bill say aye. Those against say no. The ayes have it. Clause 160 is ordered to stand part of the bill. Clause 161.
General penalty.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Any proposed amendment? In the absence of any proposed amendment, the question is as many as are in favor of clause 161 standing part of the bill say aye. Those against say no. Clause 161 is ordered to stand part of the bill. Clause 162.
Observation of other laws.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Any proposed amendment? As many as are in favor of clause 162 standing part of the bill say aye. Those against say no. The ayes have it. Clause 162 is ordered to stand part of the bill. Clause 163.
Insurance coverage.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
Any proposed amendment? In the absence of any proposed amendment, as many as are in favor of clause 163 standing part of the bill say aye. Those against say no. The ayes have it. Clause 163 is ordered to stand part of the bill. Clause 164.
Civil proceedings.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? Honourable members, in the absence of any proposed amendment, the question is as many as are in favor of clause 164 standing part of the bill say aye. Those against say no. The ayes have it. Clause 164 is ordered to stand part of the bill. Clause 165.
Research vessel.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
Honourable members, it is for your consideration. Any proposed amendment? Yes, Honourable Dr. Kabiru.
Mr. Speaker, I am just wondering if the chairman could provide explanation to this kind of, I'm on 165, right? For this kind of right to the commission to, set aside law passed by this act, by this parliament. Just for February, I'm mindful of 23.296, as you also referenced yesterday, Article 23.296, because I received it. But I feel something is not right if law is being passed by this parliament and a decision is taken that the commission can set aside any provision of the law if he deems so fit. So if they can provide some explanation to that.
Honourable member, what is this provision saying? The head note is research vessels. Yes. So it's not fishing vessels. It's not involved in fishing activity, but they are conducting scientific investigation. And it reads that for the purposes of a search or a scientific investigation, the minister may, on the advice of the commission in writing, exempt a vessel or a person from all or any of the provisions of this act. And it is for the purposes of research only.
Mr. Speaker, issues of research and academic exploits, there is an agency responsible for that. And if without recourse to those agencies, the commission can just...
Which agencies?
Mr. Speaker, we have GTEC. Mr. Speaker, if it has to do with scientific research in an area, say the various centers for scientific research are authorities. And I don't think it is proper that the commission, under the reason of research or scientific exploration, they can just set aside a provisional code. There must be something in the law that make reference to maybe recommendation from those respective agencies. I so submit, Mr. Speaker.
Chairman of the committee. Chairman of the committee.
Mr. Speaker, I didn't quite get convinced with his argument, and I reject, and I think that we should allow the current rendition to stay.
Yes, Honorable Sosu.
Yeah, thank you very much, Mr. Speaker. Mr. Speaker, I share the sentiment of my colleague, but it is okay for a law to create an exemption where necessary. And for the purposes of not abusing that exemption, that is why the rendition is the way it is, that requests will be made, and it's going to be upon the advice of the commission in writing before they are exempted. Now, Mr. Speaker, when you look closely at the object of the bill, particularly you look at the object of the bill and look at in the long title and you look at its application. Obviously, the bill does not intend regulating the work of research vessels within that context. So I believe that the rendition is appropriate as it is, Mr. Speaker.
Honorable Kabiru, you raised the issue. That's the view of members.
Mr. Speaker, Mr. Speaker, I think I now appreciate where the Honorable Kabiru is coming from. But, Honorable, Mr. Speaker, this is a research vessel. It's not for any other fishing expedition. It's for scientific purpose that will generate data and science expertise that will help us govern the industry proper. And so it's safer that there's an exemption for these specific vessels. And I think that the current rendition should stay, Mr. Speaker.
Mr. Speaker, may I find out from the chairman, is that the standard position in the industry?
Honourable members, for instance, if food and agriculture organization is conducting a scientific research into fishing, do we want them to go through GTEC?
Mr. Speaker, they can go through the Center for Scientific and Industrial Research. Yes. So that's why I'm saying that. That's the point I'm making.
Is that what is done internationally?
Mr. Speaker,
in fishing waters?
Chairman, is that the standard thing that goes on? Okay.
Mr. Speaker.
Honorable Samuel.
Yeah, Mr. Speaker. We know vessels can come into the country on our shores for other activities aside aquaculture and fishery issues. So if we can qualify, because people could come into the zones to deal with fisheries or aquaculture on the verge of, by stating that it's on for research, but they will be engaging in aquaculture, so we will have to qualify that for the purpose of research or scientific investigation.
Yes, on that note, I agree perfectly with you that we should tie it down to a research into a scientific investigation into fishing and fishing
and
activities.
aquaculture resource,
Yes,
yeah.
very well. And then after exemption, we should also, in line 2, we should also say a research vessel or a person from all or any of the provisions of this act. Because if you say exempt a vessel, it's as if it is all vessel that can be exempted, contrary to the head notes. So the new rendition should be for the purposes of a research or a scientific investigation into fishing and aquaculture. The minister may, on the advice of the commission, in writing, exempt a research vessel or a person from all or any of the provisions of this act. Yes, Honorable Champo.
But, Mr. Speaker, if I may ask, can the minister responsible for fishery on its own exempt payment of fees? They can't do that. They have to work in consultation with Minister of Finance, and Minister of Finance will direct GRA so that they have something called practice notes. So in their practice notes, they can do that, but on their own, they can't exempt payment of fees. They can't do that. They can't do that.
Yes.
I support my colleague, and this is because when it has to do with research on the high seas, a lot of things happen. A lot. There are instances of things happening in Pram Pram. A lot. And if care is not taken, and we don't constitute a proper body, and we just leave it to the minister, although the rendition is that you would have to, for the purpose of a scientific risk investigation, the minister may, on the advice of the commission. Speaker, it's just a humble prayer that we should relook at this and have a solid body. Because you see, just like my colleague raised, there are issues of taxation. So you may need the Ministry of Finance to also be a part of this discussion. You need, not me, you need. In fact, you shall need. So let's else, just the reference I made, you can go to Pram Pram.
Honorable members, I think payments that you refer to are related to licensing being issued. So my understanding of this provision is that when it is a fishing, a research vessel, or a vessel conducting an investigation into, let's say, fish poisoning, they will not apply and get license before they do so. So if they will not go through the licensing requirements, where lies the payment? Yes, Honorable Roxon.
Speaker, you are right. Speaker, let's read clause 1 of the law. Clause 1. Clause 1.1. Application of the Act. 1.1. Unless otherwise specified, this Act applies to all areas over which the Republic exercises jurisdiction or sovereign rights. B. Fishing and fishing-related activities and any other activity or matter within the scope of this Act. C. Persons, vessels, vehicles, aircraft, exports, all that. So, Mr. Speaker, the provision in question, which you eruditely interpreted, is that 1651, for the purpose of a research subject to the amendment carried, or scientific investigations, the minister, which in this case the Minister for Fisheries, may, on the advice of the Commission, in writing, exempt a vessel or a person from all or any of the provisions of this Act. So it's not speaking about tax matters at all. Yes, all matters. In this law, hold on. In this law, in this law, we haven't done anything in respect of grant of taxation or waiver of taxation and all. So I agree with you that the minister can be mandated under this provision to waive the legal regime for procuring licenses in order to do fishing. If the purpose for which they want to conduct any activity at all is for scientific data gathering. That's my understanding.
So, honorable members, let's look at it this way. I'm just making an example. Let's say Parliament is part of Ghana waters, and there is an information that fish around this area is poisoned, as a result of which there is the need for even our own Council for Scientific and Industrial Research to conduct a scientific investigation as to whether or not indeed the fishes are poisoned. You want for that to be done, they should go through the requirements of acquiring the license before they go in to conduct the investigation. Then by that time, we would all have been dead. So that is why the power is then given to the minister to take an urgent decision to address the matter without allowing that particular vessel coming to conduct the research, coming to conduct the investigation, to go through the rudiment of acquiring the necessary documents to be able to do so. Yes, Honorable Achampong.
Mr. Speaker, that's why I refer to practice note of Ghana Revenue Authority. When they bring in perishable goods, they can't get the time to go through all the processes. So they grant the exemption, and then they send it to the Ministry for ratification.
You see, Honorable Achampong, this one, we are not talking about perishable goods. We are talking about our own life.
This is an example. This is an example that I made. But Mr. Speaker, even they are supposed to pay some fees or license fee. It comes under fees and charges.
Yes, that is why I am saying that
the ministry must make an input, give those numbers to Ministry of Finance, and the fees and charges must be brought to this house for approval.
So, Honorable Richard Achampong, Honorable Richard Achampong,
Already we have to give them the
Honorable Richard Achampong, the discretion is being given to the minister here. Does not relate to where a vessel is having a perishable goods. They are talking about scientific investigation. So, for instance, the example that I am giving, that, somebody pour some chemical as a result of it in our Ghana waters, that is poison. Life is threatened. You understand? In a situation like that, you want the minister to go through the process of taking all the deep notes, but that is the very thing that the law is talking about. It reads, for purposes of research or a scientific investigation. It is only for the purposes of research and scientific investigation, but nothing more.
Speaker?
Yes?
In fact, the minister will not be doing so suo motu. The minister will be Mr. Speaker. Mr. Speaker. Mr. Speaker. In fact, the minister is not doing so suo motu. The minister may be doing so based on the advice of the commission. So this is a real regime in place. So please, let's Speaker, put
Honorable members, another example is that in our fishing waters, there is oil spillage. Yes, and the international organizations are coming to research and conduct investigation into that particular matter. We want them to go through the rudiment of acquiring license, making payment before that is done.
Speaker, you are right. Speaker, put the question. Let's go.
Yes, Kabiro, you raised the issue.
Mr. Speaker, the chairman of the committee, who happens to be my lecturer, yes, and I think I must I must put it on record, knows the point we are making, that when it comes to any research, ethical standards are required. There are rules and regulations, whether it is research related to pandemic, research related to spillage of oil in the Red Sea or in the high seas. There are rudiments guiding research. Industrial research, academic research, there are rules guiding that. Mr. Speaker, I agree that the law should have flexibility for the minister to waive certain provisions of the Act to allow research to happen. But under the current...
Dr. Kabiru, if there is an outbreak of a disease and there's going to be a research conducted into it, you go by the procedure that you are spelling out.
Mr. Speaker, it is not this particular law has made provision for force majeure, and the force majeure under that's what we can do. And this is one of the, but I'm saying that, to say that the minister, in his determination with the commission, says that there is a problem which has to do with scientific or industrial research. I am suspending this act. That's the meaning of it. I am suspending this act, and that every provision in this particular act is not... I am saying that when you say you are waiving provision of the act, you are suspending the provisions of the act. I know, I'm speaking in context. So when I'm using the word, take time and listen. Okay? So he's saying that he's suspending this particular act in relation to scientific research. I think that, Mr. Speaker, it is too broad, it is too wide, the net is too wide for the minister.
Move amendment and let me put a question on it.
Mr. Speaker, you want to?
Speaker, let me allay his fears. Let me allay his fears. I see the perspective he brings. But Speaker, under clause 169, we've given an elaborate regime for which the minister is mandated within 12 months upon the coming into effect of the law to bring regulations. So if the concern is that the power to waive is discretionary depending on the circumstances, the regulation would itemize the conditions under which the waiver...
Honourable members, for me, when it is a research into fishing, the regulator cannot be GTEC or Council for Scientific and Industrial Research. The regulator is the Fisheries Commission. Is that not the case? And they are saying that the minister, on the advice of the Fisheries Commission, may, because the minister will not just get up to do ABCD, on the advice of the regulator, which is the Fisheries Commission.
Mr. Speaker, maybe I'm wrong, maybe, Mr. Speaker, but when it comes to research, the regulator is not, especially research within the regulator is not the respective commissions. Research in the country is regulated by respective authorities. And to say that when it comes to research on fishing matters...
You see, you are picking the word research in isolation. Probably that is why you are running into difficulty. Now, if Council for Scientific and Industrial Research wants to go into fishing, to research into fishing, under normal circumstances, but not for this provision, they will need the appropriate licenses from the regulator to be able to conduct that particular research. You understand? There is oil spillage. UN is also coming to investigate and research into that particular matter. To be able to do that, they don't need the consent of our scientific and research department, but they need the consent of the regulator to go there with the fishing vessel. Because Council for Scientific and Industrial Research will not grant permit for a fishing vessel to be used in any area, in any manner whatsoever. It is the Commission that will have to grant permit it is the commission that will have to grant licenses for that to be done. Now, all that this is saying is that when that situation occurred, then the minister, on advice of the regulator, that is the commission, can allow such research, such investigation to be conducted without going through the rudiments to make the application. The application will be determined, and then license issued to you, a permit granted to you before you do that. So in a situation like that, that is all that the provision is talking about. I do not think if there is oil spillage, UN is coming, they will need the approval of Council of Research, Scientific and Research, Industrial Research, to be able to do that. That one will be a complete absurdity. So if you still insist on your amendment, you move a motion and then we put a question. Yes?
I insist that my brother should advert its mind to 1691C. We are saying that the minister will by regulations, provide for the conditions for industrial, semi-industrial, and foreign vessels, including the conditions for authorization of marine research. Marine research. So you can't insinuate that it's only CSR that has the power to regulate research matters. No. This House has the power to enact laws to give mandate to other institutions to go into marine research. So, Kabiru, disengage and let's make progress.
Dr. Samuel.
Mr. Speaker, research could be short-term, medium-term, and long-term, depending on the agency and the need for it. So to cure the mischief, in addition to the mischief of abusing the license regime and any omnibus issue, I would suggest, in addition to inserting fisheries and aquaculture to the investigation, I can also add, because to cure that CSR or any other relevant institution that might be into research, we can add, on the advice of the Commission in collaboration with the relevant agency institution.
Well, when it comes to granting of permission in this nature, I cannot foresee any relevant institution that has the authority so to do. It is only the Commission and the Minister. So we cannot be subjecting. No, the member has an amendment, so I can't put the question. No. I think we've heard a lot. Will you abandon the amendment, or you want to move the amendment for me to put a question on?
Mr. Speaker, I abandon it, but with your proposed amendment, I will own it and then we will proceed. Thank you very much, Mr. Speaker. And I think you get the proposed amendment made because we needed to get that clear, Mr. Speaker. So we can proceed.
So, honourable members, one of you should own the rendition and let me put the question. That. Owing very well, very well.
Mr. Speaker,
as many as are in favor of the proposed amendment say aye. Those against say no. The ayes have it. The amendment to clause 1651 is accordingly carried. The whole of clause 165. As many as are in favor of the whole of clause 165 standing part of the bill say aye. Those against say no. The ayes have it. Clause 165 is ordered to stand part of the bill. Clause 166.
Guidelines, directives, or notices.
Mr. Speaker, we have no advertised amendment.
Honourable members, it is for your consideration. Any proposed amendment? Yes, you have the floor.
Mr. Speaker, thank you for the opportunity. I kindly seek your guidance. 1162. The Commission shall publish guidelines, directives, or notices issued under Section 1 in Gazette. Mr. Speaker, we've had previous 166, 1662, 1662, 162. Mr. Speaker, my point is the Commission shall publish guidelines, directives, or notices issued under subsection 1 in the Gazette. Mr. Speaker, we've discussed some public issues about publication in the previous clauses, where we said in the widely circulated newspaper.
Honourable Member, I think notice of guideline, directives are just like a notice of the bills and the laws that we pass. And the appropriate place for which that is done is when it is done in the Gazette. So even constitutionally, it states that Article 106, for a bill to be introduced, apart from a bill being introduced under certificate of agency, it must be published in the Gazette. So this provision is appropriate. As many as are in favor of clause 160 standing part of the bill say aye. Those against say no. The ayes have it. Clause 160 is ordered to stand part of the bill. Clause 167.
Collaboration with other authorities.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
Honourable members, it is for your consideration. Any proposed amendment? In the absence of any proposed amendment, the question is as many as are in favor of clause 167 standing part of the bill say aye. Those against say no. The ayes have it. Clause 167 is ordered to stand part of the bill. Clause 168.
Fines and forfeitures.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Any proposed amendment? As many as are in favor of clause 168 standing part of the bill say aye. Those against say no. The ayes have it. Clause 168 is ordered to stand part of the bill. Clause 169.
Regulations.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
It is for the consideration of the House. Any proposed amendment to clause 169? As many as are in favor of clause 169 standing part of the bill say aye. Those against say no. The ayes have it. Clause 169 is ordered to stand part of the bill. Clause 170.
Interpretation.
Honourable members, interpretation, clause 170. Yes. Majority Chief Whip.
Speaker, my indication, and I've agreed with the minority that there's some indication that the Tuna Association will want to engage the House in respect of some technical terms captured here. So, Speaker, on that note, we want to pray that we bring today's consideration to an
So
end.
let's defer 170 and then the transitional provisions and the repeals. As for that one.
And those four provisions.
Yes, so we can take the transitional provisions and the repeals.
Great. Thank you, Mr. Speaker.
That one, they are standard provisions.
Yes.
So, clause 170 accordingly deferred. Clause 171.
Repeal and savings.
Yes.
Mr. Speaker, in respect of the application being made, in fact, there is actually a petition from the Tuna Association. So when we engage further, then we'll come back to it, maybe hopefully by Monday. So I'm just supporting his application.
Clause 171.
Repeal and savings.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
Honourable members, any proposed amendments? As many as are in favor of clause 171 standing part of the bill say aye. Those against say no. The ayes have it. Clause 171 is ordered to stand part of the bill. Clause 172.
Transitional provisions.
Chairman of the committee.
Mr. Speaker, we have no advertised amendment.
Any proposed amendment? In the absence of any proposed amendment, the question is as many as are in favor of clause 172 standing part of the bill say aye. Those against say no. The ayes have it. Clause 172 is accordingly ordered to stand part of the bill. Honourable members, we've come to the end of consideration stage for today. Yes, Majority Leader, any indication? Yes. Yes, Honorable Second Deputy Speaker.
Mr. Speaker, let me thank you for the opportunity. It's just an observation that today I am elated to see such a number in the chamber at the weekend. Today is Saturday, taking part in lawmaking, consideration. Mr. Speaker, some of us who were here in the 8th Parliament and even beyond, we never got such a number actually taking part in the consideration. And what even makes me more elated today is that you see that most of us are freshers, first-timers, and they are actively taking part in the lawmaking. I think we need to commend ourselves and urge them to do more. In fact, when you talk of parliamentarians, this is an actual function, lawmaking. You know, delete, add, this is very, very at times frustrating. But seeing such a number actually taking active part, I think we need to commend ourselves. Yesterday, Mr. Speaker, I think you mentioned it, and seeing the numbers today, I think we need to. And we urge all of us to take this.
Thank you very much.
Especially all of us.
Thank you very much. Yes.
Speaker, may I seek your leave so that you want to support?
If I may corroborate what our respected Second Deputy had spoken to. And Speaker, you set the tone yesterday when you urged, particularly you single out the whips to apprise ourselves of the potentials and members who have shown. And coincidentally, Speaker, yesterday, all our members who stayed on were all first-time members. All of them were first-time members of Parliament. And it's very encouraging. And it also speaks to the fact that, well, majority means something, but really, it's about what your determination. So, it is about your determination to stay relevant and to support. So, Speaker, I'll further pray your outfit, and I see the clerk also gazing. Let's make a dedicated effort to train members of Parliament, especially in legislative drafting. I think it shouldn't just be by the way, where occasionally we get capacity building programs and then one or two attend. Speaker, let it be a dedicated one. And I know, Speaker, you are very passionate about lawmaking and you have shown a lot of authority in this area. We should go beyond the passing statement. Well, we want to do it. Let's do it. Let's be dedicated to it. And I hope that when we are doing it, Speaker, we shouldn't attach so much. We shouldn't be too concerned about ratio. We shouldn't be too concerned about ratio. No, it is not about ratio. It's about the potential shown. The Honorable Kabiru, the Honorable
Ralph and Co. All of them have shown potentials. And let's not be overly moved by ratio. Let's look at the potential and what
Honorable
people
members,
bring to the table.
I started yesterday. So today I'll add my voice in highly commending members, particularly today being Saturday. The number of the first-timers that I have seen from both sides taking part in the legislative process is very, very, very encouraging. We should keep it up. I'll repeat my proposal yesterday that all the first-timers that show interest in the legislative work must be supported so that we can unearth their talent. We can really develop their talents in the legislative work. The core business of Parliament is to legislate. That is why we call ourselves the legislative arm of government. So if people are not showing interest in the legislative work, then are you here to perform oversight and only representative function, which for me may be secondary to your legislative work? So I task the whips, both the minority and the majority whip, to start doing some work. And together, we'll pick it up with the House and then decide how best we can unearth the talent, develop more interest into the legislative work. So I will urge upon you to keep it up. And once you grasp it, and then the interest is there, you are good to go. You are good to go. This one alone can keep you in Parliament until you decide you no longer want to come to Parliament. There are people who are not in Parliament today, but they are forever remembered for their role when it comes to legislative work. And yesterday, I mentioned some of them, and it has once again gone into our records. So please, keep it up. It is together we can make laws and good laws for the Republic of Ghana. Yes?
Speaker, I may want to add my voice, but before then, let me pray you that we take item number 7B. Speaker, it's a tall list of papers that we have to lay under the name of the Minister for Education. But Mr. Speaker, the Honorable Minister for Education is unavoidably absent. So may I invoke the rules under Order 96 to pray you that you permit me to lay the papers on his behalf.
Yes, that is the application.
Mr. Speaker, I don't think my colleague should be invoking any order now. He can only appeal to you that he should be, because you are not a minister. So we support that you can do it. There's no problem about it. I'm on my feet. Chief Whip. I'm on my feet to support you. I'm on my feet to support you. So let me finish. Huh? Okay, I'll read. No.
Mr. Speaker, for the records, Mr. Speaker, Order 96 is the effect of presentation of papers. Speaker, Order 96 is the effect that a paper may be presented to the House only by the Speaker, the chairperson of a committee, a member, a minister, or head of an independent constitutional body. So, Mr. Speaker, as a member, Yes, I'm a member. A member is defined by the rules. Check the interpretation for the definition of a member. So, Mr. Speaker, may I pray you to permit me to lay these papers on behalf of the minister.
Mr. Speaker, we don't have any difficulty in the majority chief whip laying the papers, but it must be on record that today's Saturday sitting, not a single minister or deputy minister is in the chamber. That must be made, and the record must capture safe. So, but he can do it. He can lay it, no problem. But there's no single minister or deputy minister in the chamber. But he can do it.
Honourable Member, I think Honourable Yusuf has come to the House. Honourable Yusuf. Yes, are we in agreement that we lay all these papers together?
Speaker, you see, we, on this side, we are not obstructing government business. We are set out to help you prosecute government business. That is why we are not objecting. So note this day. So when it becomes important that we appeal to you to also compromise, I hope you will do. Speaker, on that score,
So, honourable members, do we do so on Monday? Do we do so on Monday?
Oh, Mr. Speaker, I'm praying that we can do it. No. Oh, let's lay the papers. No, please. These are papers.
Mr. Speaker, we have no objection. He can do it.
we are masters of our own rules. We've been here before, Speaker. The practice has been that where papers are advertised in the name of ministers, oftentimes the majority leader and leader of the House has been permitted by the Speaker to lay those papers. And in this instance, we have the able, respected, capable majority chief whip. Speaker, he should be allowed to do it. Speaker, may I invite you to allow the chief whip to lay the papers. It's important. Our committees are ready to do justice to this business, and we cannot delay any further. No, we should proceed. We are masters of our rules. Yes.
What is the sense of the House? Yes, Majority Chief Whip. Majority Chief Whip.
Speaker, we are ready if we can take the lead.
Very well. Item numbered 7B at commencement of public business.
Annual statements by the Audit Committee of the Koforidua Technical University for the year 2024. Annual statements by the Audit Committee of the Ola College of Education, Cape Coast for the year 2024. Annual statements by the Audit Committee of the Accra Technical University for the year 2024. Annual statements by the Audit Committee of the Kumasi Technical University for the year 2024. Annual statements by the Audit Committee of the Adan College of Education for the year 2024. Annual statements by the Audit Committee of the Presbyterian Women's College of Education, EBRI, for the year 2024. Annual statements by the Audit Committee of the Complementary Education Agency for the year 2024. Annual statements by the Audit Committee of the University of Education, Winneba, for the year 2024. Annual statements by the Audit Committee of the Atebubu College of Education for the year 2024. Annual statements by the Audit Committee of the University for Development Studies for the year 2024.
Honorable members, the reports per item numbered 7B at page 2 of today's other paper from 1 to 10 are all duly presented, and they are referred to the committee responsible for education for consideration and report. Yes, any indication?
Speaker, I indicated I want to add my voice before I pray for adjournment. Speaker, let me commend the chairman and members of the Committee for Food and Agriculture for the diligent work. It's been a very difficult bill. It was withdrawn and brought back. This is a bill that we are taking under certificate of urgency. And Mr. Speaker, like you said, for instance, the National Assembly in the Federal Republic of Nigeria, they have a postgraduate program in legislative drafting in their Parliamentary Training Institute. So members who take interest in drafting really get trained, and you don't enter the National Assembly and leave the way you came. So this will be a good litmus test for us to be sending some of our young men and women who are showing great progress and interest in drafting, as we call it, to nearby Nigeria periodically to train, and also go for other parliaments like the House of Lords, the House of Commons. Myself, I got the opportunity with you to train, and also train in Washington, D.C. We train in Canada, in Ottawa. Mr. Speaker, but the point I'm making is that those other national assemblies who offer you formal training, maybe 2-3 weeks course, 1 week course, but the Nigerian one takes you through the formal training. You are offered a qualification, academic qualification in legislative drafting, postgraduate program. So it helps. We can do it as a long distance program. It helps. So Parliament, and I'm happy that Craig is here, it will help us to develop more talent, like you said. So my back, all of you, we want to commend you as well as the minority. Speaker, Peter, to you and I, we used to be like 15 that participated in this process. Now, or sometimes 6, just 6 of us. But today, we have over 45 of us being interested. And the interest will grow more, especially when members get to know that opportunities will come with it. So, Speaker, we thank you. This is all that we are all asking for. Taking interest in the business of the House and participating in it. This is what your constituents will see. Like Speaker said, all the efforts to go for re-election may be achieved with your diligence and industry displayed during this business of this matter. So, Speaker, with these words, I move that in the absence of any further business, today's proceedings be brought to an end till Monday when we come back. I thank you for the opportunity.
Motion move for adjournment. Any seconder?
Mr. Speaker, I second the motion. And in doing so, Mr. Speaker, the majority chief whip, the training that you spoke about, it's not only Nigeria. Many members will want to go to the Commonwealth in the UK and other places. So don't limit it to Nigeria. And then, Mr. Speaker, also for the record, in the drafting process, especially with this one, it is over 90 members who are interested, not 45, for the record. We are over 90 today for that record. So I second the motion for adjournment.
Honorable members, motion has been moved and seconded for the adjournment of the House. The question is, as many as are in favor of the adjournment, say aye. Aye. Those against, say no. The ayes have it. The motion is adopted. This House is accordingly adjourned till Monday, 14th July 2025 at 2 o'clock in the afternoon.